Hello, everyone. My name is Bashni Veersinghe. I am an attorney in California who practices estate planning and business law. And today I wanted to do a quick video on what is the difference between a will and a trust and which one would you need? So, this is a question that I get frequently. And as a result, I thought, let's just dive in and talk about it. So, really, to understand which document you need to understand how these two documents work. So most people just instinctively know that these are two documents that are often concerning inheritance rights, right? So it's how we decide who we're leaving things to. So with a will or trust, you can designate who your beneficiaries are and what you're leaving to your beneficiaries and under what conditions you're leaving things to your beneficiaries. You could do this with both of these documents. But there are differences between the two, and I wanted to explain to you what those differences are. So, one of the primary differences between these two documents is how they function while you're alive. So, while you're alive, if you have a will, what you have done is basically written out what your intent is, who you intend to leave your estate to. Now, that intent can change at any time between when you first write it to the moment of your death, as long as you have the capacity, meaning mental capacity, you are a person of sound mind, you could make changes to your designations as to who, what, and how they're going to inherit, right? You could update those as life happens. But on the trust side, while it is true that you can make changes depending on the type of trust you have. For simplicity's sake, I'm going to cover what a revocable trust is because that's the most frequently used by estate planners in our current era. So, with the revocable trust, what you're doing is you're creating a document that stands on its own. Once the document is created and you sign, everything you can and cannot do is depending on what the terms of the document are. So the document itself will state whether or not you could make changes to the designations as to the beneficiary, uh, what you're leaving them, how you're leaving it to them, all of that. Generally speaking, when you create a revocable trust, our client is the person who's creating the trust. So you're going to give your client the most amount of tools that you can. So generally speaking, if an attorney is drafting this trust, they are going to make it clear that the trustor, sometimes referred to as settlor, sometimes referred to as grantor. It all means the same thing. The person who's creating the trust, whose property is going into the trust, that person is going to have the ability to make changes in the trust, including, because it's revocable, that they can revoke the entire trust and basically scrap it and take the assets that were placed into the trust back into their own name at any time, so long as they have capacity. So capacity is something that you must always have in order to make any kind of change. And the reason is I mean, not just estate planning, any kind of legal document, you need to have capacity. And the reason is that we don't want people who don't have a full comprehension of what they're doing to be making changes to documents when, or entering into documents if they don't fully understand what they're doing. So, but just like a will, a trust can be amended, it can be updated, and so long as the terms of the trust allow for it, that they can. So So how they can be changed is similar. But what is different is that with a trust, that document is effective upon signing, meaning that while you're alive, that document gives authority to whoever you have named as trustee. Typically, with the revocable trust, you're going to name yourself as the initial trustee and the initial beneficiary. And the reason is that while you're alive, you want your financial assets to work for you, right? Like you want to have control over it, you want to be able to. Uh, Invested in however you like, you want it there for you to access whenever you need. But after you pass away, it also has successor beneficiaries and successor trustees. So people who will be in charge of it and people who will receive portion of it will be listed in that document. And those designations can be changed, as I said, so long as you have capacity and the document allows you to do so. Uh, so that's one really big difference between a will and a trust. Other big difference that you need to consider is what happens after you pass away. Now, with the trust, one of the primary reasons that people create trust is to avoid probate. And so you might be wondering, what is probate and why do I want to avoid it? Well, probate is the court process for when somebody passes away, where the court oversees how that transition from the person who had died to their beneficiaries happened. So the court would authorize somebody to be the executor or an administrator, depending on whether there was a will or there wasn't a will. And that person is legally responsible for making sure that everybody who needed to be notified is notified, that any copies of the will is given to whoever the beneficiaries are, that they collect all of the assets, do an inventory, pay off any debts that need to be paid off, and then distribute according to the will, or if there is no will, according to state law, which is known as intestacy succession. And I'll do another video on intestacy at a future date. But that's basically how probate works. And the reason why anyone would want to avoid this, because it does sound great, right? Like it's good to have a court overseeing that process. What's bad about it is the time it takes to get through probate. You're looking at 12 to 18 months, assuming there is no uh, contention, that no one is contesting the will or the beneficiary designations. There's no infighting happening. There's no litigation that's happening. Because if those things are added on, that probate process becomes even longer. And there are also fees involved with probate. So probate is not a process that typically you would want to do on your own. You are going to want to hire an attorney to help you with probate. And when you do that, the attorney is going to take attorney fees, which here in California, we have statutory attorney fees, so that there is there's a cap on how much the attorneys are going to be taking. But they take 4% of the first $100,000, 3% of the next 100,000, 2% of the next 800,000, 1% of the next $9 million. So you can see how it will add up really quickly, and that's money that could have gone to your loved ones instead of going through the probate process. And it's time that you could have saved for your loved ones so that they don't have to go through this process. So that's the big reason why people don't want to go through probate, is time and money. And with the trust, you don't have to go through that court process. So that's the other big difference. So if you don't have a will and your estate is worth over $150,000 here in California, then you're looking at probate. If you do have a will and your estate is worth $150,000 or more, you're still looking at probate. The way to avoid probate is to do a trust. So you might be thinking to yourself, great, I need to do a trust. Well, it really depends on whether or not you own assets that are going to trigger probate. So that's a different video I'm going to do in the future. But keep in mind, the number that we're looking at, the triggering number is $150,000. If you own real property, meaning a house or land in California especially, you should be thinking about doing an estate plan. And before you take any action, always pause and talk to an attorney. Don't just rely on YouTube to make these decisions, because they do have legal ramifications that you need to understand before you take those steps. So please keep in mind that everything in this video is intended for informational purposes only. It's not intended to constitute legal advice. There is no attorney-client relationship being built between me and you for watching this video or by you sharing this video. But you do need to talk to an attorney in your area, that in your geographic area, that practice in estate planning, and talk to them about your situation. What assets do you own? What are your objectives? Who are you trying to leave things to? Under what circumstances? And they can give you advice based on your actual situation, because depending on various factors, the advice is going to change. So keep that in mind. And also, if you like this video, please like the video, give me a thumbs up, and please add a comment so that I can make more videos for you on whatever topic of interest that is to you. So if there's a question in your mind that you would like answered, put it in a comment, and keep in mind that the comments are public, so please don't put personal information on there. But if you have a generic question without going into the nitty-gritty personal information, you could put it in a comment and I will try to get to it. So thank you for joining today, and I hope you learned something. I look forward to more videos in the future.